Hi everyone, thank you for joining today for the masterclass on Australian Privacy Act and Principles for Clinical Trials. Today I'm joined by my colleague Idriss, who's a data protection lawyer in MDT's Belgian office. My name is Edward, I'm a data protection officer based in MDT's London office. The context and the agenda for today will essentially be Idriss giving a deep dive onto the current legislation in Australia for data protection, the Australian privacy principles, and the intersection with clinical trials and how us as data protection officers and data protection lawyers assisting pharma companies in the sphere can properly comply and adhere to the legislation when conducting trials in Australia. Little background to myself. I previously worked as a data protection lawyer in China with a specialty more so in Chinese data protection, but also throughout Southeast Asia and Pacific. I'll switch on now over to Idriss to actually go over the bulk of the content. And then later on, when he's finished, I'll address the future proposed developments of the Australian Privacy Act. Idriss.
Thank you, Edward. Hello, everyone. I'm Idriss Awagoum, Yonta. I'm data protection lawyer at MyData-TRUST. And today we are going to discuss about a complex but very interesting topic. And our main goal today will be to show you how to master Australian Privacy Act and Principle for Clinical Trial. This live discussion will be to address the main question you will have concerning data protection law in Australia, with a specific focus on the life science sector. In case you have any question, a dedicated session will be addressed at the end of this presentation. So let's jump into the content of this session. Next. So basically, the Australian Privacy Act 1988 is the principal piece of legislation protecting personal data in Australia. It's designed to promote the protection of individual privacy in Australia and by imposing obligation to organizations processing personal information. Let's take a look at the history of the law. The Privacy Act was passed in 1988 and entered in force in 1989. This law have had a lot of amendments, but we just select the most important. And in 2001, the law have been amended to be extended to the private sector. In 2014, they have a major change in the law, and one of these major changes was the introduction of the Australian Privacy Principle, which replaced the Information Privacy Principle. In 2018, they also amended the law to introduce the Notification Data Breach Scheme with additional requirements regarding data security for some organizations. And currently, there are some discussion about the proposed major change in the law in Australia. As Ed explained, we will talk much more later about this change later in this presentation. Let's take a look to the general overview of the law in Australia. At the federal level, we have the Privacy Act 1988, which set for the data principle for processing personal information. Besides, some state and territory have their own data protection law, which apply only to public sector. And finally, some sector-specific law may provide additional requirement to your organization depending where you're processing personal data. For example, for healthcare sector, if you are processing personal data in Victoria, Australian Capital Territory, or the state of New South Wales, those privacy sector law will apply to your organization. And the National Supervisory Authority at the federal level is the Office of Australian Information Commissioner. Next. So, as we are talking about Australian privacy law, we can take a look to some main concepts. For example, personal data is defined as information or an opinion about an identified individual or individual who is reasonably identifiable, whether the information or opinion is true or not, and whether the information or opinion is recorded in the material form or not. Another interesting point, which is really different from the GDPR, is that credit information, tax file number information, and employee record are included as a special category of personal data in Australia. Another main concept is consent, which is defined in Australia law as express consent or implied consent, which is a little bit adjudgent from the one of the GDPR, but that keep the four main elements of the consent that we also have in the GDPR. So now let's take a look on the scope of the application of the law. Actually, the scope of application of Privacy Act is really close to the one of the GDPR. At the first point, it's only cover data of natural person. So the data of legal person are not under the scope. Regarding the material scope of the law, the Privacy Act apply to all processing of personal information, basically object of the processing. And one is come from territorial scope. The Privacy Act apply to all foreign organizations deemed to be carrying on businesses in Australia, regardless whether or not the organization is actively collecting personal data. Any foreign organization that provide services or products in Australia will be carrying on businesses in Australia and subject to the Privacy Act. This scope is really close to that of the GDPR. Let's take a look now of what are out of the scope of the law. The Privacy Act do not apply to employee data. An employee record is defined as personal information relating to the employment. It does not also apply to small businesses. And small businesses can be defined as an operator with an annual turnover less than 3 million Australian dollar, approximately 1.9 million euros. But there is an exception for this because if your small businesses are using or disclose personal information for benefit or provide a health services and hold health information other than in the employee record, he will be subject to the Privacy Act. Now we can use some example to better understand the scope of application of this law. Basically, your organization will be subject to the law if it's processed personal data that was collected in Australia, if part of the data processing take place in Australia, or if the company intend to carry out businesses in Australia. And more specifically, if your company process personal data of data subject located in Australia, for example, in case of clinical trial, or if data processing of your organization take place in Australia by using laboratory based there, or if your company use a server which is operated in Australia, typically a CRO using a cloud service provider in Australia. In all these cases, the Privacy Act will apply to your organization. You also need to keep in mind that if you are a sponsor and you already conducted clinical trial in Europe, in EU, or you're already subject to the GDPR, and you want to extend your clinical trial in Australia, you will have to comply with both the GDPR and the Privacy Act. Now let's take a look to the interaction between the Privacy Act. As we mentioned in the beginning of the presentation, that we have some specific law sectorial. So let's take a look on the interaction between those legislation. Basically, if your organization process personal data or sensitive personal data in the state of Victoria, in the Australian Capital Territory, or in the New South Wales, in addition to the Privacy Act 1988, these specific sectorial law will apply to your organization. And this will result on the fact that this specific law will add additional requirement to your business, and including in terms of transfer. And when it's come from transfer here, it's not about transferring personal data outside of Australia. Is that if you are processing sensitive personal data, for example, in Victoria, and you want to transfer this personal data to another state, for example, Queensland or New South Wales, you will have additional requirement regarding transfer. Now you know how, or you know if the law can apply to your organization or not. So let's now take a look of the main requirement of the law. This is the Australian privacy principle, which are the cornerstone of the privacy protection framework in the Australia privacy law. It sets out in Schedule 1 of the Privacy Act, and it's applied to the company that are covered by the Privacy Act. It also addresses the standard right and obligation that the organization needs to comply with when it comes from the processing of personal data. So basically, if you are under the scope of the Privacy Act, you will have to comply with all of these 13 Australian privacy principles. For example, open the Australian Privacy Principle 1, open and transparent management of personal information, require your organization to process personal information honestly, fairly, and openly. And this also includes to have a really clear privacy policy that explains how your organization processes personal information. For example, another example is the Australian Privacy Principle 2, which comes to anonymity and pseudonymity, which allow individuals to deal anonymity if they desire to, or to deal with a pseudonym when it comes to the processing of personal data when it's possible. But this principle have some exception. All these principles are emphasized by the data minimization principle plus the accountability principle, which is at the heart of the Privacy Act. One of the main requirements of the Privacy Act is to have the privacy policy, and this obligation arising from the Australian Privacy Principle. So your organization must have a clearly expressed and up-to-date policy about the management of personal information. And this privacy policy may be printed on a paper, available on the website, or displayed on a mobile device screen. When it comes from a legal basics, generally in Australia, you need to know that consent as a legal basis is only required when it comes from the processing of special category of data. For other types of data, the processing is authorized on the sole condition that you need to provide information to the data subject before the collection of the personal information. And they also have permitted general situation where you can process personal data, for example, for defense or legal or equitable claim. And they also have permitted health situation where you can process personal data without the consent of the individual. For example, if it's necessary to provide a health service, if it's required or authorized by or under an Australian law, or if it's collected in accordance with the rule established by competent health or medical body. Like another piece of legislation, the Privacy Act grants data subjects with certain rights to better enable them to take control over the way their personal data proceed. In this case here, as you can see, that the Privacy Act allows individuals to exercise the right of information access, correct, to withdraw their consent or to lodge a complaint. And you can also see that some rights that are applicable in the GDPR are not in the Privacy Act for the moment. And when it's come from the timeline, you need to answer to the request made by the data subject as in the reasonable period, and we understand that this should not exceed 30 calendar days. And bear in mind that, like we explained, that we have some sectoral specific law that some state law may provide additional right. For example, in Victoria, you have the right to data portability, but this right does not exist in the Privacy Act. So depending on where you are processing your personal data, you can have additional requirements regarding the right. For example, if you take the case of the clinical trial, the legal basis which will apply to the processing is consent, and these consents need to be informed, and the data subject need to give the consent in the voluntarily way. The consent needs to be current and specific, and the individual has the capacity to understand and communicate the consent. You can also process personal data if you are in the permitted health general situation. And for example, you can use personal data if it's required or authorized by under Australian law, or if it's collected in accordance with rule established by competent health or medical bodies. And when it's come for further use of data, when you collect, because we have a principle of purpose limitation, if you want to use your the personal data you collect for a primary purpose, for a secondary purpose, when it comes from sensitive data, your secondary purpose needs to be directly related to the primary purpose. But for other data, your secondary purpose needs to be related to the primary purpose. In any case, If your secondary purpose is not indirectly or directly related to the primary purpose, you will need to request consent of the data subject to be able to process personal data. Another main requirement which has been introduced in 2018 is the notification data breach scheme. In the Privacy Act, an organization is obliged to notify the individual as well as the national supervisory authorities when, in case of any eligible data breach. An eligible data breach is understanding to be a breach which is likely to result in a serious harm for the data subject. And you have for the time frame as soon as practicable after you become aware of the data breach. Another main point is that an organization has 13 days to determine whether or not an eligible data breach has occurred. In this case, basically, is that your organization suspect that it has suffered a data breach, but the organization is not sure that the data breach can be qualified an eligible data breach. In this case, you have 30 days to determine and to assess your data breach. And if the result of your assessment show that it's an eligible data breach, you will have to notify both the individual and the national supervisory authorities as soon as practicable. Another main requirement regarding international data transfer is that before disclosing any personal information outside of Australia, your organization must take reasonable steps to ensure that the overseeing profession will handle personal information in accordance with the Privacy Act. But this does not apply if your organization reasonably believes that the recipient is subject to a law or abiding scheme substantially similar to the Privacy Act, and individual can access mechanism to enforce protection. Or your organization inform the data subject about the fact that there is no similar protection and the data subject agree, or the disclosure of personal data is authorized by the law. But if you do not have this exception, you will have to put reasonable step to be sure to ensure that the official recipient will handle personally in accordance with the Australian privacy principle. And we should understand reasonable step as putting in place an enforceable contractual agreement that require the recipient to handle the personal information in accordance with the Australian privacy principle. So now we are going to take a look on what are considered as the best practice in the Privacy Act. First of all, when it comes to data protection officer, it's the case to achieve good privacy governance in the Privacy Act. It's highly recommended by the national data protection authorities and is really similar to that of the GDPR. And it is also important to keep in mind that there is no notion of data protection representative in the Privacy Act. When it comes for the data protection impact assessment, it's considered as a good practice. So the National Supervisory Authority may direct an agency or organization to perform a DPIA for all high-risk processing projects. And the National Supervisory Authority consider that it's a good practice and that it can be the proof of the demonstration of commitment to good practice as well as the compliance with privacy legislation. When it comes from contractual agreement, the data processing agreement is highly recommended. For example, in the case that you engage a contractor to perform servicing on your behalf, or where you want to disclose personal information outside of Australia. And also about joint processing is highly recommended. For example, in case many organizations are processing personal data at the same time, and they can discuss between them who between them will be the one who will notify data subject and the National Supervisory Authority in case of the data breach. So for the penalty, if your organization found to be in breach of many violation of the Privacy Act, you may expose yourself to a penalty up to the curated of 50 million Australian dollar, approximately 32 million of 32 million euro, and 30% of revenue for the period of the breach or 12 months for your organization. And if it's an individual, you can have a 2.5 million Australian dollar or approximately 1.6 million euros for the breaches of the provision of the law.
But yeah, so after as we've mentioned, the law has been in effect for over 30 years. And following the introduction of the GDPR in 2018, which is really seen as, let's say, groundbreaking globally, and there's a lot of successor laws following it, such as the PIPL in China, the Brazilian law, which really took the GDPR as an inspiration or influence in how to draft, let's say, model text legislation for different jurisdictions. The Australian Attorney General's Department was commissioned by the federal government to provide a report on how the Australian Privacy Act should be updated. This report was initially commissioned in December 2019 when the review was announced, and it went through 2 stages of public review. The initial public consultation ended in October 2020, and then there was a second tranche of public consultations in October 2021. This ultimately led to a fairly extensive report at the start of this year in February, which is over 320 pages, in which the Attorney General's office has proposed 116 substantial changes to the current legislation. Then this September, the federal government provided a response to the Attorney General's office, or the Attorney General's department, on the proposals, the 116 proposals, which essentially summed up with 38 proposals were agreed with, 68 proposals were agreed with in principle, and 10 of them were noted, which is quite an unusual way of acknowledging and then completely disregarding what the Attorney General's office proposed. So obviously, agreed is relatively straightforward. It's what most lawyers would actually kind of understand as agreed with in principle. That is, the principle is agreed, and the federal government will move forward implementing this principle into draft legislation. That being said, there wasn't that many of them. Most of them were agreed with in principle, which you would imagine should be the same as agreed, but it's a little bit more murky. They've gone back to the Attorney General's office looking for either further consultation or further development on how practical it is going to be to introduce it into legislation. And the federal government is really approaching it not just from, let's say, the legislative standpoint on how to protect the individuals. Obviously, that's a core component of the legislation, but also the burden and the cost that's going to be imposed on companies when starting to comply, and the significant cost and burden in bringing these laws into effect. The noted, as I mentioned, is basically just, thanks for bringing this to our attention. We disagree with it, and that's that. If we can move on to the next slide there, please. So yeah, essentially, the Attorney General's office looked at the GDPR and really, really appreciated some of the factors, some of the points that were introduced by the GDPR. I wouldn't say it's a carbon copy, but there's a lot of things are fundamentally the same. What is important to note that right now we have to advise, and what we have to do is look and advise and comply with current legislation. This advice by the Attorney General's office has to go back before the government for review. Then it'll be drafted into a bill, which will go before Parliament, and then that'll be debated, changed. It'll go back for review again and debated and changed again. But some of the key considerations or key recommendations by the Attorney General's office was an introduction of the controller processor distinction, broadening of the definition of personal information, not just personal information that is about someone, but also to include relating to someone. So if it's not clearly definable as personal information, but it can be attributed to an individual, like an identifiable person, then that will be considered to be personal information. A considerable one would be the removing of the small business exemption. However, this was only agreed with in principle because it's quite a significant change to impose on companies, which ultimately, for the most part, will not have any bit of compliance because they're completely exempt. Bringing a statutory tort for serious invasion of privacy. A considerable change is the data breach notification. So presently, under the current system, there is a data breach notification of 30 days. They are bringing it much more in line. They're going to recommend bringing it much more in line with the GDPR, where you have to notify the Office of the Information Commissioner in Australia, the OAIC, within 72 hours of a notifiable breach. Another aspect where they've, let's say, taken a carbon copy, so much of a carbon copy that they haven't even changed the names, is the standard contractual clauses. So they're going to bring this in conjunction with the Office of the Information Commissioner, identifying certain jurisdictions around the world which provide comparable protection to the Australian privacy principles, the APP. That would be considered to be very comparable to the GDPR's adequacy decisions with different jurisdictions. Obviously, the APP they're substantially similar, but not equivalent. And we have to give consideration of what the Australians really rate higher than, let's say, what the Europeans will rate higher. The Australians are really approaching it from a business-centric point of view, whereas in Europe, let's say, we're really approaching it from the perspective of protecting the data subject. There's also a recommendation to introduce privacy impact assessments. So we commonly call them data protection impact assessments for high privacy risks. There's no real kind of definition of what these high privacy risks are quite yet, but it's agreed with in principle, and there will be further consultation. I'm cognizant that I'm being told to hurry up, so I'm going to skip ahead to the next slide. So they agreed there's 38 key bullets, and agreed in principle the 68. The key bullet points here. With the agreed in principle, this is where the bulk of the changes are. Like agreed information that's substantially automated. There's a slight difference here with the GDPR. So under Article 22 of the GDPR, we have the automated processing activities. However, the Australians have actually gone a step further than what we do under the GDPR. We're substantially automated. So even if the entire process isn't automated, you can imagine, let's say, CV submissions. A lot of companies now use automated filters for filtering out unwanted CVs or people who don't have the correct criteria that companies are looking for, and filter them out. But ultimately, the decision is left up to an individual. So it's not really falling under automated processing. However, the Australians have taken the approach of substantially automated processing. So even the very factor of using the automated pre-filter will make this processing activity fall under this proposed legislation, which the Australian government has agreed with in principle. They've also agreed to expand the powers of the regulator, which of course every government authority is going to do so. And they've agreed to prescribe countries and certification schemes which are comparable with the Australian privacy principles. They have also substantially changed and agreed to change the concept of repeated. So like the term repeated, from serious and repeated interferences with privacy. Right now, it's, let's say you've done something that's illicit, processed a bit of information that you shouldn't have. As long as it's not repeated, like it's a once off, you're not really considered to have done something too dreadful. But by removing this repeated terminology, or well, the term repeated, they're really, really strengthening the protections of the individuals, and they're focusing a lot on vulnerable people, which of course, if they take the attitude of the GDPR, vulnerable people will actually be everyone involved in a clinical trial because they, in theory, are patients. Agreed with in principle, most of these, again, it's agreed and agreed with in principle. You kind of imagine they're fairly similar. The agreed with in principle, there's going to be a little bit further discussion and further analysis by the Attorney General's office. But one of the key ones, I've already kind of slightly touched on them, will be the data breach notification, the privacy impact assessments. There is one which is quite notable, which is the obligation to determine and record the purpose of processing of personal information. So kind of a step towards creating a records of processing, but not quite to the same extent that we do have under the GDPR. There's a huge amount. I mean, there was 68 and I had to cherry pick enough to fit onto one slide. So I think we can skip on, and if people have questions or if they have more kind of concerns about a particular area, I'm sure I'll be able to answer them. If we can move, yeah. So the further developments, the Attorney General's office is back in place. So the ball has been returned to the court, to the Attorney General's office. The agreed with are now going to be drafted as for legislation. So the actual articles in the Privacy Act are going to be drafted for, let's say, the enactment or the modification of the current Privacy Act. The agreed with in principle is the Attorney General's office is going to explore and inspect the practicality of bringing these kind of agreed upon changes to the legislation, but bring it in such a way that it's not going to be severely detrimental to companies carrying out business in Australia. There was also a proposal for, let's say, kind of a grace period where the company is going to be informed and given a timeout period to be able to bring themselves into compliance with the proposed legislation. A further detailed impact analysis, and the government has asked for further advice to be given in 2024, further consultation, and then actual proposals of legislation which will be debated in Parliament. In essence, this means that realistically, we're going to be looking at summer or autumn next year before the legislation becomes effective. So we're really, when looking at the services and when looking at the kind of, if you're carrying out processing activities in Australia at the moment, you really have to comply with the current legislation, but be cognizant and be aware that the future changes are going to change to a degree that would be more comparable to the GDPR, and it would be wise, or at least prudent, to start kind of future proofing, or at least bring a term privacy by design. Anything that you are doing, factor in these proposed changes and these agreed with in principle into what you are doing, so you can be better prepared, rather than, let's say, the government proposes the bill in the summer and then it gets enacted, let's say, in December next year, and you contact your lawyers and say, oh God, we've an activity coming on, we need to get prepared straight away. I mean, it's, of course you can do it, but it's not really advisable. Next slide, please. So yeah, what are the steps to become compliant? We have several activities here. Sorry, I'm not sure if we're on the correct slide. Yeah. So of course, the most important thing is awareness training for employees. It's all very well that you put your policies into place, you put your processes into place, but if your employees and the people who are actually handling personal data aren't fully cognizant of what they're doing, or the risks that are associated, or even more importantly, like the liabilities for the company, then putting all the documents and the procedures into place isn't worth anything if the employees aren't fully aware on how to act on them. The second most important, well, actually these aren't ranked in most important, but the second is having a privacy policy which follows the Australian privacy principles, includes all the mandatory language, but also looking towards the proposed changes to the legislation, taking into account what the proposed changes are, and almost putting into effect best practices or future-proofing yourself, rather than drafting a privacy policy now and then revisiting it in 6-12 months time, and then asking the staff who've already undergone their awareness training to go back to it again. Which, I mean, I work in data protection. I don't want to say I read privacy policy for fun, but certain people are a lot more willing to read privacy policies than others. So I'd say this is definitely, do it once correctly, get people to understand what's happening correctly, and don't come back to them with different definitions 6 months, 7 months further down the line. Internal procedures. So this is kind of building privacy by design, ensuring that everything you've put into place is following the correct procedure, following the correct process. You are adhering to certain principles such as data minimization, adhering to retention periods, which is another thing which is agreed with in principle. So presently, there's no specified need to have retention periods in Australia for your data in your privacy policy. Under the agreed with in principle proposal from the Attorney General's office, it's going to have to be included in your privacy policy. Appointing a data protection officer. This is always highly advisable to either have a data protection officer or a data protection lawyer fully aware of all your processing activities, all your activities that you're carrying out, the person who's going to be responsible for carrying out your privacy impact assessment for the company, for the processing activities. In Australia, for the high risk processing activities, whatever they may be, we still don't have a full list or a definitive list of what these high risk activities are, but one can kind of extrapolate that they're going to be related to genomic information, financial information, which is an unusual one for people coming from a GDPR perspective, where financial information isn't protected, unlike in China, where PIPL does protect financial information. The Australians have taken the same approach, where financial information is to be considered sensitive, or at least high risk information, and if it gets lost. Putting in effect data transfers. So this is really kind of more future-proofing your processes, because under the agreed with in principle, the Australians are going to introduce their, I don't know if they're going to call it standard contractual clauses. In the Attorney General's proposal, they are called standard contractual clauses, but I would imagine they'd like to stick a little Aussie twist in it and just call it something slightly different. And also the adequacy decision. So another jurisdiction which is comparable with the Australian privacy principles offers the same level of protection, identifying which ones of these. So let's say you're conducting a clinical trial in Australia, but you're an American sponsor. You have labs in Singapore, throughout Southeast Asia, but also in EU, UK, Switzerland, how to be able to accurately and properly transfer the information between all these different jurisdictions. Because of the close links with America and Australia, you could probably surmise or extrapolate maybe the Australians be a little bit more kind of willing to give the Americans a proper adequacy decision, unlike the Europeans, where we have call it a partial adequacy decision. But again, this is something that we really have to examine when the legislation gets proposed. And then again, data processing agreements, because there is the suggestion to introduce controller processor relations, there's going to be a lot of extra liability imposed upon controllers, whereas the processors are going to be acting under instruction, so the liability will flow up towards the controller, i.e. the clinical trial, the company sponsoring the clinical trial. So making sure you have the correct contractual language put into place to properly protect your entity for any activities that are happening in Australia. And then, of course, the privacy notices, informing, because Australia is a consent-based jurisdiction, there is the possibility of kind of like, let's say, implied consent in Australia, but they are really stressing how the privacy notices, and it's agreed with in principle again, how consent must be very freely given, but the language and the way the information is explained to the data subject must be done in a very clear, very straightforward manner, informing the data subject of all their rights and their abilities to withdraw, bring in a right of erasure, for example, how to avail themselves of these rights. Of course, if you are carrying out activities in Europe, will be pretty familiar with all these activities, but there will be a slight Australian twist on them again, as it won't be a carbon copy, whether it's for national pride reasons, or let's just imagine the Australians are more practical about business, so they'll be weighing slightly towards the commercial side of things and balancing it that way rather than towards the data subject. I think we can move on to the next slide. Okay, thanks. Yeah, so if you have any questions, I'd also just like, before we move on to the questions, to, I don't know whether it's announce or just invite, MyData-TRUST is hosting a data privacy event. It's our 11th one on January 23rd in Brussels. It's focused on data protection for life sciences, and the title is Bridging Theory and Practice in Data Privacy, Exploring the Nexus of Health Data and Privacy. It's a networking event for experts, both in data protection and for people coming from the pharma side, coming from the client side, coming from the regulatory side, to mingle, just to share ideas, share how technologies are changing and how we can intersect the two, the legislative compliance and groundbreaking processes on how to properly advance clinical trials. So if anyone's very interested or even slightly interested in attending an event in Brussels, the tickets are available on the MDT website. I'm not 100% if they're free or not. You'll have to ask Roger and drop a message. But yeah, it should be a good event, and looking forward to seeing everyone there. Okay, thank you.
Yeah, thank you. You may have one first question, but I think you already addressed this, because the question is, how long does this usually take for those changes to be actually into the legislation?
How long is a piece of string? Yeah, so it's very difficult. What we have seen is the federal government taking the approach where they're really trying to get the legislation correct, and they've only agreed with 10 out of 116, where they don't want any discussion, they don't want any further analysis, whereas there's 68 points there's 38 that they've agreed with, 10 that they've just noted and said, please disregard, don't bring this to our attention again. And 68 they've agreed with in principle, but these 68, let's say, are the bulk or the core components of data processing. And they've requested further analysis by the Attorney General's office. Because of that, because it's, let's say, more than half of the actual content provided by the Attorney General, it definitely won't be in the first half of next year, I would imagine. But yeah, the Australians are updating their Data Protection Act, the Privacy Act, in a, let's say, fragmented manner with a series of amendments rather than reissuing a new legislation. So they may bring about the 38 agreed with as they're approved, with minor amendments to the Act. I'm not sure if Idriss has any further comments on that.
Okay. We have another question regarding role qualification in Australia, but I will answer this one by saying that for the moment there is no role qualification in Australian law. So basically, any organization that falls under the scope of the law will be subject to the Privacy Act and will have to comply with Australia privacy principle. But maybe this will change with the expected change in the law, as it's explained. So we are still waiting to see what will come into effect, because they propose to introduce the processor and controller role qualification as those in the GDPR. So for the moment, we do not have a role qualification, but this may change in the future.
Yeah, just to add a little bit extra onto that. So the actual formal response from the federal government to the Attorney General's office ended with bringing Australia in line with other jurisdictions to the operational reality of modern business relations, and to reduce the compliance burden for entities acting as processors. So they're really attributing most of the liability onto the controller, onto the entity that's directing, kind of like, let's say, vicarious liability if you're talking about employment law, but really attributing all the liability onto the controller. Presently there isn't, but yeah, in the future, whenever the amendments are effective, it will be a difference between the two roles.
Okay, so we are reaching far out of the time, so I propose to close our LinkedIn Live here. We thank you very much, and don't forget that we, MyData-TRUST, are there to support you. You can contact us by scanning one of the QR code available on the screen, and we will be there to support you. Thank you very much for attending this masterclass.